Well, hello, everybody. It's Pat, and it is New Year's Eve. I spoke with the people down in Richmond at the legal department this morning, the hotline, about this honor before rather than honor about for closing. And the guy down there said technically it's a breach of contract if you don't close in a timely manner with that clause in there the way it is. But I said, but what is the penalty for that? Because there's no damages. And he had to agree with me there. He said it was kind of like when you say time is of the essence. But here's the recommended best practices. I said, does it mean you don't have a contract if you don't close on the closing date? What's the judge going to say about that? He said, I have no idea. But here's the best way to do it. Um, First of all, Vonda suggested give yourself plenty and plenty of time. In other words, if it's a 30-day closing, put 45 days in there and tell them you'll close earlier if you can, but you don't want to be redoing paperwork. If it turns out you're going to be late, it's recommended that you do an addendum and not the day of closing or the day before closing, but maybe a week early, so everybody knows where you are on the same page. But it's not been tested. This thing hadn't been tested in court yet to see if it it is technically a breach of the contract if you don't close on or before that date. But anyway, uh, that's the best we've got from Richmond. Go ahead and give yourself plenty of time. Um, do an addendum ahead of time if you need to extend, or just give yourself plenty of time to close and explain to the other agent that you'll close as fast as you can, but you don't want to be scrambling around at the end because of this new clause. So that's our recommended best practices for now until we hear something else. And that'll do it for today. Thank you all very much and Happy New Year to you. Bye bye now.